compel either the market or the market players to enter into a more competitive arrangement? To be more specific, I'd like to use the example of the telcos. Assuming you disapprove the 700 megahertz purchase, can you actually tell PLDT and Globe to allow San Miguel to enter, or can you tell the market na papasukin niya yung San Miguel? Because arguably, over the last year, market opportunities have already been lost. What can you do beyond approving or disapproving a deal?
Good afternoon. I would tread very carefully regarding your question specific to the telecoms industry, because that is obviously pending litigation before the Court of Appeals and Supreme Court. So if we look at it from a more general, a broad perspective, yes, the provisions of the Philippine Competition Act are broad enough such that we can impose significant market power obligations on players or participants in a particular market where they have a dominant position and secondly control essential facilities. So you can imagine the kind of sectors which would be susceptible to these kinds of powers that may be exercised by the Commission. Now, insofar as the question of compelling a particular investor or business entity to make an investment in a particular market, obviously we cannot force an investor to buy or engage in a business that he has made a business decision not to get into. Okay? Now, however, the flip side of that is, can we impose a condition for a particular transaction or for a particular acquisition to not include certain businesses or certain aspects of that transaction in the deal that is subject of review by the PCC? Absolutely. That is within our powers. So that would imply that we can, within the powers granted to the PCC, we can influence the way the market operates, the way participants in that market behave and operate. Okay? But it would be, I suppose, presumptuous for us to say that if person A does not want to make an investment in market C, that we can compel him and tell him, no, we force you, we force your stakeholders to make that decision as company A to make that investment. That is not the way competition law works.
So that is a significant shortcoming in your mandate, to be restrained to a bad cop role forever, di ba? Don't you think so? I mean, apart from actually fostering competition, your focus seems to be on the preventive side, preventing monopolistic.
Well, not necessarily. I would have reservations about that broad statement, because part of the powers of the PCC would be, number one, as you have already mentioned, to foster, to enhance competition in the market. And that's a very strong tool to have, because within that mandate lies an array of tools that we can avail of, right? Secondly, in terms of the kind of prohibited agreements and conduct that are provided for or sanctioned under the PCA, again, we have an array of tools that we can impose. So it's probably a misleading statement to say that we are constrained or restricted from...
Understood. A final follow-up, if I may. Are you in a position to break up a company that has come into a monopolistic position by its own abilities in the market, for example, not by acquisition? Sobrang lumaki lang siya sa sobrang galing niya. Can you break it up?
Well, ang operative term din is kung sobrang galing niya, and I would suppose that would redound to the business acumen of its managers, the efficiencies with which it operates its business. So those are conditions which the law recognizes as legitimate means to attain a state of bigness in the market. So that is not prohibited. However, if in the manner that it attains its dominant position, it exercises abusive conduct, then that is what would make it within the purview of competition law. Ano yung mga abusive conduct na yun? Nakalista naman yun sa batas. You know, there are several items which would constitute abusive conduct.
Likha Cuevas from Merger Market. Does PCC have any hand in the PSAs, the power supply agreements that power gencos and distributors have? Say we have now several pending cases with ERC regarding the PSAs. Like for example, a distributor is also a power generator, so that in efficiency wise, yes, it makes sense, but then again, power distribution is a captive. They have automatically captive market. So or kailangan ba ang ERC mag-invite sa inyo to look at these PSAs?
Let's take a first crack. No? Number one, the PCC has primary and original jurisdiction over all competition-related matters. So to the extent that there may be competition issues with regard to that particular situation that you mentioned, which is a distributor similarly acting as a power generator, in competition law parlance, there is a vertical agreement which might have some anti-competitive object or effect, then the PCC is within its mandate to look into that. Now, with regard to the particular example that you were alluding to, I think the EPIRA, which ERC, for instance, is tasked to enforce, has provisions which limit, in terms of percentage, the amount of equity, the amount of participation that an entity will have to observe when it is involved in both generating and distributing functions under the energy sector.
Let me also note that in the way we are proceeding with our cases and with our work, what we are promoting is for PCC to be working smoothly, efficiently with other regulators and government agencies. That's why we are into signing memorandum agreements to define how we can share information, how we can partner with certain issues, share data, and so on. So that's going to be a part of the culture that we build in the enforcement of our law. So in the case of ERC, we are also in discussion with firming up a memorandum agreement. We have one already with the Security Exchange Commission. We are almost in the final stages with similar memorandum agreement with DSP, with Insurance Commission, and some others. So, in other words, what we hope to achieve is that whenever there are issues like that involve other government agencies, that there are ways by which we could coordinate our actions so that it does not create a burden on business.
Maybe Likha, it might be good at this point to make a distinction between a sector regulator, which is, for example, ERC, versus a competition authority. So a sector regulator would play an important role in sectors with market failures, for example, natural monopolies. But in the case of competition authorities, we cover all sectors of the economy and all types of establishments, including GOCCs, right? So, however, and the sector regulator like ERC would look at things, for example, like pricing. So, in the case of PSAs, they would have to approve the pricing in those contracts. PCC only steps in if there is a competition concern. And dito po pumapasok yung sinasabi ni Kong Joey na primary jurisdiction for competition.